it's troubling to me because if the notwithstanding clause is there to enshrine the supremacy of Parliament into the Canadian Constitution, how can a court rule on that? Wouldn't it require a constitutional amendment? If the court can put like conditions or restrictions on the use of the notwithstanding clause, then the court is supreme, not Parliament. The notwithstanding clause should not be amended by a court. The whole point of it is that it's saying the court has no business, or the court should not be supreme in respect of these particular sections of the Charter. So is it? I mean, who gets the last word? Is it the court or Parliament? Hello, welcome to the next episode of Beneath the Law. Gavin Tighe here. Stephen Thiele, how are you, sir?
I'm really good, Gavin. How are you doing?
I am doing pretty good. I'm here just dog sitting while we record this. Actually, you can't dog sit your own dog. He's actually human sitting.
Yes. He's taking care of you.
Yeah, I'm taking care of my little dog while I'm here on my own. So if you hear a little barking, that's him looking for attention.
That's good to hear. You're in a better place than I am. I am sitting in our offices in downtown Toronto, but notwithstanding that, I'm still in a good mood.
Notwithstanding, yes. Notwithstanding has been a topic of late in a great number of cases, and the discussion surrounding our famous notwithstanding clause in the Charter of Rights here in Canada, in our Constitution, which is to say that you have a Constitution and a Charter of Rights, except for if we don't.
Well, and that was the key compromise in order to get our Canadian Charter of Rights and Freedoms. So, a very interesting political discussion as a case is headed to the Supreme Court of Canada on Quebec's secularism law, I guess is what is going to be argued.
Right.
And determined, and whether there should be some guardrails put around the use of the notwithstanding clause.
Yeah, it's so the secularism law, we call it that. It's basically a pretty well known piece of legislation out of the province of Quebec, which frankly does have some pretty, strange pieces of legislation, frankly, in terms of legislating what language people can put signs up on, for example. And this one was what people can wear to work if they work for the government. And what the legislation basically said was there won't be any religious identifying garments or symbols if you're working for the government. So hijabs or any other type of religious garment or wear was banned by the government. And of course, that would provoke, in fact, did provoke a charter challenge as to whether or not that was a lawful statute. In fact, I think that one of the sections was one of the sections was struck down, even though the notwithstanding clause was used, because there was an argument under the right to vote section that if people in the legislature, for example, who were elected, were wearing religious garments, the notwithstanding clause doesn't apply to the right to vote section of the Charter. So that was, in fact, an infringement of the Charter, and that portion of the legislation was, in fact, struck down.
Right, because Section 3 is not a right that the government can actually take away.
Right. So there are certain super priority rights in the Charter to which the notwithstanding clause does not apply and cannot apply, and that was one of them. So that in the lower court in Quebec, that section that was carved out in the sense that the people who were elected to the legislature were allowed to wear whatever they like.
Correct.
But people who work in the legislature were not.
Well, that's Quebec, and I'm not even sure where their proposed legislation now sits. They actually want to ban all forms of prayer in public.
Right.
So, that this is what is going on in Quebec. They certainly have a decent history of invoking the notwithstanding clause.
Well, they have no compunction about that invoked in notwithstanding clause, and have, in fact, were the first to do it and have done it several times since.
Which has shifted, and which is why a lot of attention is now being paid to this case that's going to the Supreme Court of Canada. We've had Alberta has used the notwithstanding clause, Saskatchewan, Ontario has used it, New Brunswick has used it, Yukon Territories, I think, proposed it once as well. So we're beginning to see provincial governments threatening or warning that it will be used to protect their mandates, really, and their enacted legislation. We're seeing that. I'm not sure what's going to happen with the bike lanes in Toronto.
Yeah.
We have the premier proposing to get rid of the speed cameras. We talked about that topic.
Right.
And if, I can see a similar challenge
I
being
can
made
too.
to that legislation because, rights to life, liberty, and security of the person, if they're saying that speeding around school zones is causing injury or death,
Right.
you can just see that being a charter challenge.
Absolutely correct. I mean, the exact same argument that was successful at the trial level with regards to the bike lanes could certainly be mounted with respect to the speed cameras if they can find experts, which I have no doubt they would find plenty of.
There will be a lot of experts.
You can find an expert my
Right.
own bias here that I think you can find an expert to say anything if you pay enough. But in any event, they could find experts to say that speed cameras in fact reduce speeding, that speeding causes injury or harm, and therefore any law that was to take away speed cameras would affect the charter right of any of the individuals,
Right.
just like it affected the charter rights supposedly of the bike lane users who say that it endangered their life if the bike lanes were taken away.
Yeah, so we can see that happening. Gazing into the crystal ball, there's a lot of saber rattling going on right now. Although this is a legal podcast, this certainly drifts into the political now. In terms of what was the purpose of the notwithstanding clause to begin with. And we talked about that a little bit earlier in the podcast, that was the section that permitted the Charter of Rights and Freedoms to actually be born.
Yeah, absolutely. Right? So it comes down to the Great Compromise. I mean, Canada is not the United States. It's a very different type of democracy. The primacy of Parliament has always been the notion of the Westminster system of government, which is the Canadian system. And in 1982, when the Charter was finally brought into place, when the Constitution was repatriated, as people would say, the compromise was that there was a group of premiers, including the Premier of Alberta, I think the Premier of
Peter Lougheed at the time,
exactly, was spearheading that, who said, no, there's no way that we are seceding the right of Parliament or the government of Parliament or the electorate who gets to elect people to go to the legislature. We're not handing that power over to the judiciary as the final arbiter as to whether the law passed by Parliament is valid or not. So there has to be a release valve in terms of some of these things that we can pass the law, even if a judge were to say it offends the Charter, and that we have the right to do so, notwithstanding that it offends the Charter. And so that's where the notwithstanding clause was born. I mean, the compromise on it is, if a legislature uses the notwithstanding clause, they've got to bring that legislation back before Parliament and renew it, so to speak, 5 years later.
Right. Why that matters, clause. Right.
Why it matters is because, of course, we have elections every 4 years. So, in other words, if a government wants to use the notwithstanding clause, and I think, in fairness, if a government invokes the notwithstanding clause, they kind of admit that the law breaches the Charter. Otherwise, why would you invoke the notwithstanding clause? If you thought the law complied with the Charter, you wouldn't do so. You're certainly hedging your bets that a judge might find it to be non-compliant. So you certainly identify that there's a risk that it's not compliant. But you've got to go back to the electorate. You've got to go back to the voters and say, and get reelected again, and or the successor government has got to go back to the voters, and it becomes a political issue. So ultimately, the notwithstanding clause gives supremacy to Parliament. Parliament does get to pass laws regardless of the Charter, but Parliament has to go back to the electorate and get that use of the notwithstanding clause endorsed by the electorate in an election cycle and bring it back on again.
Yeah, and the politics of this is very interesting to me. Being a former student of political science and spending a lot of hours looking at Canadian politics in particular, and being in university, just getting into university at the time that the charter was passed, the compromise is very interesting. And in terms of the sunset clause being there, the 5-year clause, basically limiting the elected lawmaker because they do have to go back to the electorate. And then just the language of the clause being as open as it is to allow the government to invoke the notwithstanding clause. They don't have to identify what provision in an enactment their declaration applies to. It's blanket, and they don't have to identify which right they're taking away per se. So to me, when I look at that, and there are arguments that, well, they can only use it in an emergency, is really taking away the compromise. And the other argument that we're seeing now is that regardless of the notwithstanding clause being used, the court should still have an ability to determine whether the legislation infringes against the charter. And we saw that ruling in the Saskatchewan Court of Appeal decision in the UR Pride case recently. And, I sit here in Ontario, and the question that it puts in my mind is, if the notwithstanding clause is used, isn't the judgment of the court moot? And why are we wasting judicial resources, arguing about that?
Yeah, it is moot. I mean, I suppose that the court is saying, yes, it does infringe the charter, and it's a bit of an academic exercise in making that ruling.
But it's an expensive academic exercise.
It's extraordinarily expensive academic exercise. But I suppose that there's a political element to that too, because I mean, the use of the notwithstanding clause, as I said, is kind of meaningless unless the legislation offends the charter. So it's kind of the converse is, I suppose, is important as well. I mean, I think that for the purposes of the sunset clause and the obligation of the government to bring that back on again after the next election, or making it an election issue, would it not be important as an election issue that the court has found that this legislation offends the Charter of Rights and Freedoms, and this government, passed it anyways. I mean, that would be something that the electorate could say, yeah, that's fine, or no, I don't like that.
Well, it would certainly support the arguments of the opposition.
Right.
But I guess the question then becomes, should an unelected judge be making that determination to, are they being drawn or sucked into the politics of it when maybe they shouldn't be?
Well, absolutely. But I mean, the notwithstanding clause in the Constitution is, in my view, inherently political. It is, and it was meant to be political. I mean, you can't sit there and go, we advocate for the supremacy of Parliament, and then say that, but the law can't be political. You've just said that it is inherently political. It's that if Parliament is supreme, then the law is all about politics, because Parliament is elected. So, I mean, I think the intersection of law and politics with respect to the charter is never more patently obvious than in the notwithstanding clause. It is a political section.
100% political. Do you have a personal view in terms of whether there should be guardrails placed around it? There's actually, just on that note, I think there's a private senator's bill before the federal parliament, before the federal government, basically saying that 2/3 of the House of Commons would need to vote in favor of the notwithstanding clause, and that it has to be 2/3 of members from two parties before the notwithstanding clause is used. Is that appropriate?
look, the notwithstanding clause is in the Constitution because it needed to be to get a constitutional amendment, which required buy-in by all the premiers, etc. And so if the point is this, if you could write the Constitution by simply a supermajority legislation in the federal parliament, we wouldn't have needed a notwithstanding clause because you wouldn't need agreement. So if you're going to amend the notwithstanding clause and put in, what they call guardrails on it, if you're going to change it, you got to change it just like you'd amend the Constitution in any other way. It's through a constitutional amendment. And that means you'd have to get buy-in from all the provinces, just like they did in 1982, and to add these words to the section. So I don't think some supermajority of parliament or something. No, you can't amend the Constitution like that. That's not the way. If it were that easy, we wouldn't be having this conversation.
Yeah, I agree with that totally too. I just don't know at the end of the day where this all goes. It could be, I guess we're seeing the use of the notwithstanding clause more and more.
Well, it's becoming, that's the key. Remember,
right.
It is inherently political. And those who were in favor of inalienable rights enshrined that would be determined by the judiciary, not the supremacy of parliament, similar to like the U.S. model, that to me is, it was kind of like a third rail, so to speak. No one will ever touch it because they know that they didn't want to go back to the electorate.
Right, there was a fear. There was a fear in using it.
But that's going to be lost if there are a series of what I would call, politically popular legislative choices that the government then gets to use the notwithstanding clause to override what is viewed as kind of an activist judiciary seeking to govern from the bench in matters of public policy. So the bike lane case to me is a classic example of that. And I think that there is a fair number of voters who don't like the bike lanes and like the fact that the government was getting rid of them, and are probably going to be pretty annoyed that their elected representatives are being overruled by an unelected judge. So that makes the use of the notwithstanding clause in that context, to my mind, kind of politically palatable. And if you can get a number of those cases going forward, the third rail element of the notwithstanding clause is going to go away. People are going to get used to the fact that the notwithstanding clause is used, and it's not going to have the stigma that I think that the framers and those who entered into it thought it would.
Well, the bike lane case, there's a great distinction between that case and the secularism law in Quebec, or even their proposed law to ban prayer in public, because to me, the bike lane case is really about money, right? It's they're spending millions of taxpayers' dollars on all these bike lanes throughout Toronto, and it's becoming a burden on the taxpayer. And as you say, majority of people drive cars, and it's really impacting car drivers. And so an elected provincial government is making a policy choice, but now the charter is getting in the way and basically causing governments to continue to spend money.
Yeah, I mean, I think that's the point, that if there is for example, special interest group that may or may not take a position on something that is popular with the electorate, and the special interest group gets their way to use the charter in a way to have public policy move in the direction they want, even though the electorate doesn't want that. That is really what this notwithstanding clause was all about. That's when those advocating for the supremacy of parliament were saying, wait a minute, this is a democracy. Democracy is ruled by the electorate. It's not ruled by unelected judiciary and special interest groups who can put forward an argument that their particular rights are being offended by some particular piece of legislation. That was the argument back then. And these types of cases, I think, really, they help that argument. They make that palatable to the electorate. They are going to take away, I think, the stigma of the use of the notwithstanding clause, make it easier to use the notwithstanding clause almost regularly, if I can say that, and what does that mean for the rest? What does that mean for the charter? It becomes a glorified Bill of Rights, as far as I'm concerned.
Well, you just took the words right out of my head there, Gavin, and I'm glad that you and I are on the same page on that. Uh, and then like that's an erosion of the rights, right?
Well, yeah. I mean, you've destroyed. If the whole thing is that if the judiciary and those special interest groups really, they are huge supporters of charter rights, then they should want that the charter to not get watered down through what will become, I think, a regular use of the notwithstanding clause, and therefore it's not a charter at all.
Well, and it'll be interesting to see what the Supreme Court of Canada judges say at the end of the day. But in my view, the language is pretty clear that the lawmakers have the ability to do whatever they want with respect to taking away those rights. The current political debate with respect to this is pitting the federal justice minister against the provincial premiers, and I honestly I don't understand where the justice minister is coming from. He just seems to be passing the buck on to the court, but I think the issue is much deeper than that.
Yeah, I think this was raised in their factum for the first time in terms of this sort of asking for some guidance on this from the court. But it's troubling to me, because if the notwithstanding clause is there to enshrine the supremacy of Parliament into the Canadian Constitution, how can a court rule on that? Like, I mean, wouldn't a legislature or the various as I said, wouldn't it require a constitutional amendment? If the court can put like conditions or restrictions on the use of the notwithstanding clause, then the court is supreme, not Parliament. The notwithstanding clause to my mind, should not be amended by a court. The whole point of it is that it's saying the court has no business, or the court should not be supreme in respect of these particular sections of the charter. So is it? I mean, who gets the last word? Is it the court or Parliament?
Well, I don't know. Isn't the rule of law supreme? So if the judges are determining what the law is, then what happens? You're basically at that point, in my view, you're creating a constitutional crisis, because that doesn't seem to have been the intent of the premiers at the time that they agreed to this contract.
Yeah, the rule of law is supreme, sure, but who gets to make the law? That's the question, isn't it? I mean, the question under the notwithstanding clause is ultimately that the laws are made by Parliament. Parliaments are elected by the electorate. Laws are made by judges, as judge made law all the time. But in terms of policy issues of public policy and whatnot, generally speaking, I think that in a democracy, it's the elected officials who are the ones who are charged with making public policy decisions and enacting legislation that reflect it.
Well, and they always say that they're acting on behalf of the majority, although I guess no parliament is ever elected by a majority. But anyway.
No, that's true. No parliament is ever elected, particularly in Canada, where we've got a multi-party system where,
right.
It's absolutely right. And I mean, certainly in a municipal election, I mean, that was a great, in the bike lane case, was a great discussion about the municipality. I mean, certainly in a municipality, the number of people who actually vote for the councillor is a very small minority. I don't know what the turnout in municipal elections is, but it's something around 30% of people vote. And of those 30%, so you're basically, even if it was a 2-horse race in terms of councillors, you're talking about less than 15% of the people that voted for the individual councillor in a particular ward. That's pretty small.
Right. And all too frequently, you see a dozen, if not more, people on the ballot. And some of the winners have basically 20% of the 30%.
Exactly. So, but that's the system we have. It is the closest democracy that we have. I mean, we have a parliamentary system in Canada. That's how we elect our elected officials. And elected officials, as I say, are charged with implementing legislation to reflect the public policy that the electorate wants. And if they don't, they won't get reelected.
Well, and in my opinion, Gavin, that's up for the opposition to raise. Oppositions are well funded. I'm not sure that the court should necessarily get involved in that, because, like I said, and we see this in Toronto and throughout Ontario, it's sucking up judicial resources and time. And there are a lot of cases that are not being dealt with. We see that on the criminal side. You get charges thrown out of court because there's no judge to hear them within, what is it now, 18 months or 2 years that a case
Depends on the
has to be
offense,
heard?
but yeah.
Yeah. So, is it the right thing to be bringing all these constitutional challenges all the time, particularly with respect to legislation that contains the notwithstanding clause?
Yeah, I mean, look, the bike lane case is a very well-funded lobby who supported the cycling and bike lanes, and obviously they were very well organized and they mounted a very good case. And I think that the Crown was frankly out-lawyered on that case, to be blunt. They were certainly out-experted if you read the decision.
And we didn't act on that one.
We did not. We did not. The Crown had its own counsel on that one. But that's important because, I mean, as I say, I think that people in a democracy don't want to have public policy dictated by a minority special interest groups who just happen to be able to mount a case better than the Crown might. Public policy is theoretically the domain of the political arena, the domain of elected officials.
Yeah, well, look, when special interest groups begin to basically frame the public policy and are victorious before the courts, it's a bit of the tail wagging the dog. But our podcast is called something else.
Yeah, our podcast is about if no one is above the law, then everyone is beneath it. Stephen, thanks again. Great discussion. A lively discussion and a really impactful discussion. It'll be really interesting to see what the Supreme Court does, if anything, if they even deal with this when this decision comes out on the Quebec legislation. So I'm looking forward to that. I think we'll have a follow-up episode at that time. So first of all, thanks to everyone for listening. Really appreciate it. Give us your comments, your ratings. We appreciate them so much. Any ideas for future episodes, we're more interested to hear from you. And as we always say, if no one is above the law, everyone is beneath it.